Okay, it is 10:45. I'm going to get started. So I think everyone is looking forward to this panel, and I don't want to cut it short for time. Again, thank you. If the panel would turn on their cameras, maybe they're on, I'm just not seeing, but Gautam and Dean Chemerinsky and Meenu, you all have your cameras on.
I see everyone.
They're on, okay.
Yeah.
So this is, one of the things that the feedback we got from last time was to do perhaps some more work on the second day of the conference on pedagogical issues. And I'm really grateful that Catherine Crump, who's one of the members of the steering committee of the Free Expression Legal Network, agreed to step up and help put this panel together. I'm very much looking forward to it. And I'm just going to turn this over to Catherine and get out of the way. Most of you know Catherine. She is a clinical professor of law at UC Berkeley, and she directs the Samuelson Law Technology and Public Policy Clinic there. Again, I'm going to keep this short. She's very accomplished. Again, the bios of all of our panelists are in the share drive. Sorry, on the web page for the conference, and I would refer you there. And I'm going to turn this over to Catherine and disappear into the background.
Thanks so much, Dave, and thanks for this conference. I look forward to it every year. So today we're going to be talking about, this is a panel named First Amendment, Friend or Foe. And we're going to be talking about teaching First Amendment law in these times when perhaps some students don't necessarily agree with some foundational aspects of the First Amendment. And so to discuss this with us today is Dean Erwin Chemerinsky, Dean of Berkeley Law School, known to all of you, I'm sure, as a scholar, a practitioner, and a teacher of the First Amendment law. He does it all. Does he sleep? I'm not sure, but he's very busy and has been very generous with many of us on our First Amendment issues as they've come up. We also have Gautam, an associate clinical professor of law at Vanderbilt, where he directs the Stanton First Amendment Clinic and has done some really interesting litigation. And then Krishnan, who is currently an associate at Davis Wright Tremaine, where she works on First Amendment issues, copyright, trademark, news gathering, defamation matters. I think we're all envious that she got right out of law school and ended up with a job like that, which is pretty much a dream job. But relevant to this panel, before she was at Davis Wright and then various other fellowships, she was a student in Yale's own Media Freedom of Information Access Clinic, and will share her perspective, having gone through one of these clinics. First Amendment has obviously been a major source of controversy in recent years. Many of us remember the violent marches by right-wing groups, particularly in Charlottesville, that led to great controversy, for example, within the ACLU about whether they should have protected the marchers and other people engaged in racist or sexist speech. There's obviously been tremendous controversy over speech on platforms and disinformation, and debate over the extent to which the government should regulate platforms or whether platforms should be left to regulate themselves. And in this new environment, we wanted to talk a little bit about teaching the First Amendment and what challenges that poses. So I wanted to start off by asking our panelists about the premise of this panel and whether they agree with it, specifically whether they think there actually has been a change in how students view the First Amendment. And Erwin, you get the benefit of age, having taught this the longest, so I think I'll ask this question of you first, and would be interested to hear you weigh in.
Thank you. It's really an honor to be part of this panel and part of this terrific conference. I think your premise is correct. I first taught First Amendment law in the spring of 1981. Over the last 40 years, I've taught free speech law to law students and to undergraduates. I've seen a significant shift in more students questioning and rejecting basic assumptions of free speech, favoring much more controls with regard to speech. I don't want to overstate this. There's still many students who have the same views on free speech as most of us would, or as when I started teaching. In spring of 1981, when I discussed whether the Nazis should be able to march in Skokie, Virtually every student in the class believed that the Nazis should have the right to do that, no matter how much it upset the residents of Skokie. In spring of 2019, when I discussed whether the neo-Nazis had the right to march in Charlottesville, there was sharp disagreement in the class, and many would have said no. I see all of this as a dean of a law school. Just tell one anecdote. In fall of 2019, Ann Coulter spoke on the Berkeley campus. It had nothing to do with the law school, though a number of law students chose to attend. Those who were going to hear Ann Coulter found themselves assaulted. Some were punched, water was thrown at them, some were spit at, many were knocked down. All of this was shown on video. Some of the students who experienced this came to me the next day. They showed me the video and they said, "What are you as the dean going to say about this?" And I put out a note to the whole school saying that on a campus, all ideas and views should be expressed. If we disagree with a speaker, we should then express our own views. That it's never acceptable to engage in what the video showed in terms of physical assaults on those going to hear a speaker. Of course, it's okay to protest against Ann Coulter, but as a law school, we have to stand up for free speech. That day, signs went up on literally every bulletin board in the law school criticizing me for defending Ann Coulter. Students came to my office. One student said, "Her presence on campus is violence against me." Another said, "Your message was like a slap in the face." If you go on the Berkeley Law website now, on the Racial Justice Hub, there's a statement from a group of affinity leaders saying that I, quote, "tout the intellectual acceptability of white supremacist views." Obviously, I don't tout the intellectual acceptability of white supremacist views, but my defense of the right of Ann Coulter to speak is taken as that. I think it's worth all of us thinking about why this shift. Why do more students now reject the basic assumptions with regard to the importance of free speech and allowing all ideas and views to be heard? I think some of it is the greater recognition to the harms of speech, and especially of hate speech. I find especially among our students of color, much more recognition that speech is harmful and want to see controls. I also recognize this is the first generation to be taught from a young age that bullying is wrong. They've internalized the message, and we should admire for them that. I reject the idea, as some have said, this is a snowflake generation. I think instead it's a generation that's particularly sensitive to the harms that their classmates suffer. I also realize that this is a generation that grew up without a significant threat to free speech. They take free speech for granted. At one point, I realized that for them, the civil rights protests in the Vietnam War were as long ago as World War I was for me. World War I seems like ancient history. The protests to advance desegregation or against the Vietnam War are that long ago for them. I also think that they're a generation that has both the benefits and the disadvantages of the internet and social media. They take advantage of it in terms of speech, but they also see the vitriol, the racism, the misogyny, the hatred over the internet, and they're reacting against all of that.
Thank you, Erwin. That's helpful. It sounds like a lot of the speech or speech protections that have proved controversial in your experience center on hate speech. I don't mean that in the technical legal sense, but just it's speech that's negative, direct, sexist, racist, along those lines. Meenu, I'd like to turn to you next. You were a student in a First Amendment clinic not too long ago, and I wonder what your general sense of your and your classmates' views were on these types of issues.
Yeah, definitely. And first off, thanks for having me back. It's lovely to be back at AAC virtually, and hopefully next year it can be in person. But yeah, to answer your question, I mean, I've been out of law school now, it's 3.5 years. I already do feel a little outdated. You know, I still watch my TikToks on Instagram. But I think more seriously for me, I think one of the biggest changes is that students are much less accepting, and I personally think rightfully so, of this traditional what's good for the goose is good for the gander logic that has often govern discourse around the First Amendment. And what I mean by that is this conception that we should just knee-jerk defend unpopular speech because it makes us all less free if some of us are silenced, even if that speech is repulsive or disagreeable. Or even that in the marketplace of ideas, truth or more well-reasoned ideas will come to the fore. And obviously, First Amendment cases are the locus for these really hard questions because they do present these choices between conflicting principles. And so what I think students are starting to peel, and I remember when I was in law school too, starting to peel away from the received wisdom of the First Amendment and ask, is that really true that silencing one silences all? And what's coming, I think, is that this is all happening against this new theoretical and practical framework of power. Who gets to speak, who doesn't, who has the ability to go to court to vindicate speech rights, who doesn't. And, I think traditional, maybe more absolutist First Amendment values are often linked to maintaining traditional, equations of power. Obviously not in all cases. The First Amendment, we all know, has had dramatically empowering effects throughout history for all groups. But I think we risk placing too much weight on this, mythical notion that the First Amendment empowers us all by default, and that is somehow innate to what the First Amendment does and can be. And so I think students are also re-questioning those theories and how they underlie the First Amendment because they're comparing them with what they're practically seeing every day in the public sphere. And I think they're identifying places where the First Amendment seems to be surprisingly absent. And I think this might be where I disagree a bit, respectfully, of course, with Dean Chemerinsky. The students have not faced, a free speech threat in their lifetimes. I think we really saw this happen with the Black Lives Matter protests of last summer. We saw tremendously disproportionate speech effects on journalists and protesters. And of course, we saw really robust First Amendment defenses of journalists, I think, like the litigation that was out in Portland. We're often left wondering, okay, but where does that leave protesters and at large? And I know there was a panel on this yesterday, which I unfortunately had to miss, but, I think there's a real void in, for example, First Amendment freedom of assembly jurisprudence after and NAACP v. Claiborne. So, and then they're seeing these, the wave of anti-riot laws that was passed after last summer's protests, the increased surveillance of protests, and they're wondering, where's the First Amendment here? And then I think another thing that has really dramatically shaped students' approach to this is seeing how there is this whole, and Dean Chemerinsky alluded to this as well, there is a whole new group of actors in the free speech marketplace that are not governed by the First Amendment, right? Of course, these are the Facebooks, the Twitters, the YouTubes, the Instagrams. So they're looking at a First Amendment that in many ways seems somewhat inequipped to deal with, these unique challenges that are coming out of the digital age, disinformation and content moderation decisions, all of which are really, closely and practically affecting free speech without ever implicating a state actor. And then they're comparing that, paradoxically with, I think, other arenas like voting rights or the protester example, where First Amendment rights would seem to be very directly implicated, and it's just not, the First Amendment's not nowhere to be found in a way. And then I think the very last thing I would say that I think is really affecting how students approach to this, and this really tracks with Dean Chemerinsky's and culture example, is this is taking place in a hotspot of speech controversies, the university. And I think obviously the university, the schools have always been a site for that, Kent State, fuck cheer, fuck everything more recently, but I do think it's on a scale and of a variety that we've maybe not seen before. From the immediacy of digital speech, you're walking around with speech in your pocket, basically, to debates about critical race theory, to deplatforming speakers like the and culture example. These are issues that students are really living each and every day. And I think for many, these are not academic questions, they're immediate ones. And so I think that obviously colors students' approach to challenging some of these traditional First Amendment values that I think historically, frankly, had, I think, a bit of a luxury to be deployed at kind of a distance.
Thank you, Meenu. That was really helpful. Yeah, I mean, I have to say, when I was sort of studying the First Amendment back in my law school days in 2003, we did sort of, hear, oh, the answer to more speech, the answer to speech with which you do agrees more speech. And we said, oh yeah, that sounds great. But I can see how current students looking at the debate even over vaccine efficacy, like that proposition for them just wouldn't pass the laugh test. And on the context of universities, I do think students expect different things actually out of their university communities than they previously did. So for example, I think they expect, leadership from deans like Dean Chemerinsky when major events happen, right? And I think there may just be more tension between that role and some of these First Amendment debates that leaves them feeling let down, right? When there is speech at their university in a way that they might not have 10 years ago. So I want to just talk a little bit about, since this is a clinical conference, about the seminar components of clinics, right? So we all generally have a seminar, and then we have the clinical component. And in the seminar in a First Amendment clinic, or in my technology law and policy clinic, where we do a lot of First Amendment work, you know, there's often discussion, and there ought to be, of topics like hate speech and platform governance. And particularly, you know, one of the things I love about Berkeley is we have an extremely diverse student body, right? And so sometimes these students are situated differently, and so the same topic hits different students differently. And so I guess I wanted to hear from you all a little bit about how you approach addressing First Amendment issues within the context of your seminars. And Gautam, you haven't had a chance to weigh in yet. And so I was wondering if I could throw this first to you.
Sure. Hi, everyone. It's great to see you all in one form or another, and to be part of this great panel today. So I'll maybe answer, Catherine, your question a little bit by reflecting a little bit about what we've talked about this far, which is, I also have a little bit of, I would not frame the panel discussion the way that I think it was at least framed in the description. And the reason is that I find that me as educator, to the degree that my students aren't necessarily thinking about free speech and the First Amendment in the ways that we might expect from lawyers or from students in the First Amendment clinic, I don't view it as my role is to try to get them to take on a specific received wisdom about the problems or the dynamics that the First Amendment is supposed to address, which is to say that I find that students who tend to be skeptical of the free speech tradition that we have, or the First Amendment doctrines that we have, often have really provocative and interesting points to make that I think are really well worth hearing, and maybe right about things that we have not necessarily questioned. And I think part of that has to do with what I think Meenu alluded to, which is that the First Amendment is hardly a site of progress for all on an equal basis, and relatively in the last few years has been notorious for its deregulatory component, particularly in cases like Janus or in cases like AFP versus Bonta, which students are well aware of. So I think that if we're going to talk about how speech empowers all, we also have to talk about how the First Amendment cases have really imperiled a lot of necessary social and economic programs. And I think it's really, really hard for me to disaggregate that. And when students want to bring that up, I think it's welcome. I also think it has to do with the ways in which, as Meenu also mentioned, that private entities who are not subject to the First Amendment govern speech in ways that are so cacophonous and incoherent, and students are well aware of that as well. And even though those entities often rely upon free speech justifications for what they're talking about or why they make their choices, I think it's hard to sort of take the doctrine at face value in multiple ways. And I think I welcome the students' perspectives on that. In the teaching, you know, in my clinic, I focus much more on skills and really save discussion of current issues towards the end of the semester when we talk both about ethics of impact litigation and social justice and then current topics. And I let the students pick the current topics, in part because I like to see what they want to talk about. And I often assign readings from many of us on this in the conference right now and in our larger community, about how we think about social media governance, how we think about hate speech, how we think about current trends. And I think that students often teach each other, right? Part of my job as clinical teachers to get out of the way of the discussions of what the students are having. And so you will get naturally in a classroom students who are more inclined to the very, very pro First Amendment doctrine, sort of having as light a touch as possible, and others who think that free speech law imperils and marginalizes minority communities. And I let the students work that out. I think it's much less top down. And I also think that for me as a queer man of color, right, as a gay Indian man on our faculty and one of the rare people, it's very hard for me to come into the classroom and not have students have a prejudgment about what I'm going to say about these issues. Sometimes I'd surprise them and sometimes I don't, but I think it's really important to be mindful of what we as the role of educator and how our individual identities, particularly on these issues that implicate marginalized communities very directly, have to be thoughtful and mindful about what our role is in the classroom, and to the degree that we can empower a seminar session that is really generative and equitable and also respectful of differing views, that's what I seek to bring. I'd also say that as a First Amendment attorney in the South, right, a state that never lacks an opportunity to pass a deeply unconstitutional or speech restrictive law, it's really important for me to have the students think about how we address these issues and figure out what we can do in a place where there's a lot aligned against us in terms of free speech protections for individuals and organizations. You know, right now my students are working on cases involving Tennessee's anti-CRT legislation, issues involving Tennessee's surveillance of protesters, social media blocking, you know, politicians trying to regulate tech companies. And I think that's where the students learning through their casework about what the First Amendment means for all sorts of different actors and communities is the best way to get those discussions, as opposed to me telling them, you know, why counter speech is effective or why the marketplace of ideas model is the preferred one or not. Let them learn from each other and let them learn through the casework is the model that I've tried to take up.
Thank you, Gautam. That's helpful. I just have a couple of follow-up questions, if you don't mind. And one is, when you're talking about sort of controversial topics, to what extent, you said students sort of have preconceived notions of your views. I just wondering, to what extent do you share your personal views? And if you do, how students react, whether they think you're sort of on one side or the other side, and how that plays out. And my other question is, when you allow students to pick topics for discussion, do you exercise any control over the topics they pick? I would think at a First Amendment clinic, the answer would probably be no, but I'm asking specifically because my clinic, we do something similar. In one semester, one of the topics students wanted to talk about was sexual assault in virtual worlds, right? Where people are embodying avatars, and some people who embody female avatars are then assaulted by others. And so we had to figure out how to structure that conversation on the fly. And I'm just wondering if you've dealt with either of those types of issues.
Sure. So on the first, about whether or not I express my views, I'm pretty sure that anyone who knows me knows that it's almost impossible for me to not express my views, although I try not to lead with them. I generally, I find it very hard to sort of, I sometimes have to sit on my hands and let the students sort of talk things through. I find that I tend to express my ambivalence or confusion because, as someone who works on these issues, I tell students that on different days I feel differently about, you know, where we are in terms of the cases, or where I think the trajectory is. And sometimes I'm excited, sometimes I'm not. And I think that's like my way of being honest and direct with what I think about these issues as a practitioner. Again, it's part of the reason that I sort of backload these conversations when the students have a level of comfort with me and with each other, to have the feeling that I'm not sort of telling them to be ambivalent nihilists like what I am. And so I think that's one way that I do it. But I think that, you know, and ever since I started teaching, it's literally impossible for me to walk into a room and not have some students have certain judgments about who I am based on my identity, what I'm going to say. And I know this because of my evaluations, right? Like when I get anonymous feedback through university evaluations and through my clinical evaluations, you know, you get all sorts of things, some of which are criticism of me specified based on my individual identity. And so what that means is that I think having the view from nowhere is just a luxury I've never felt that I've been able to have. And so I try to be mindful about not saying this is what I think, but also no one's going to get credit for parroting me. And also, this is a place for all of us to learn from each other and develop and change. And students have changed my ideas about almost everything I do, in part because I'm relatively new to teaching and a lot of it's still in flux. As to the second point, I do have a predetermined list of topics and then a catch-all other. So the way that I do it is, about 10 days before the class session, I send students a Google poll and I say, okay, social media governance, the intersection of speech and civil rights, First Amendment and economic regulation, like, and maybe 5 or 6 topics. And then I let, based on that, the highest 2 winners get to be picked. And then I sort of curate a list of articles, blog posts, law review pieces, opinions, and edit that down and give that to the students and use that to frame the discussion. So it's both a level of student input, and sometimes students have said like, oh, I want to talk about an additional topic, but the sort of limited topic list voting is sort of the way that I've been able to structure the conversation, so that if we are going to have a difficult conversation about sexual assault, for example, or or terrorism or things that might be really fraught, that I have the ability as the educator to sort of frame the dynamics in the conversation well in advance.
Thank you for sharing that with us. And I'm sorry you see those types of comments in your teaching evaluations, which is really distressing. Erwin, you don't teach a clinic seminar, but you've taught a First Amendment course repeatedly over the years. And you also, of course, lead discussions on difficult First Amendment topics. And I was wondering if you could tell us a little bit about how you structure those discussions, how you set them up, and anything you do to make sure that when you do tackle the hard issue, everyone feels like they're in a sort of inclusive and safe environment.
Thank you. Let me talk a little bit what my goals are, and then I think I'm going to talk about the techniques to address your question specifically. My goal is not to instill a particular viewpoint of the First Amendment. I'm trying to do three things in a First Amendment class. First, they need to learn the doctrine. What has the Supreme Court said and why? So if we focus on hate speech, we need to look at Chaplinsky and Beauharnais, but also the more recent cases like RAV versus City of St. Paul, or Virginia versus Black. They need to know that every court to review a hate speech code struck it down. So whether they agree or disagree, they need to know the doctrine. Second, I want them to understand the competing positions, and I want to legitimate the competing positions for them. I want to be sure that all the arguments on both sides come out. The good news here is I found in teaching First Amendment law with regard to hate speech, the students are very willing to express both sides and engage each other. I don't always find that to be true. One of the things that troubles me right now is the extent to which student pressure silences other students in the classroom. To give an anecdote, I saw this very vividly. Last spring, we were entirely online and I was teaching constitutional law. I allowed students to participate either by raising their hands or they could write in the chat, but I was the only one who saw the chat. And I would read whatever they wrote in the chat out loud on the topic. I had far more students take conservative positions on topics like abortion and affirmative action when they knew they could do so anonymously than where they would be doing so where others could hear and see them. And I think we as educators need to deal with, though I don't know how, that reality of how students are silencing other students. In the context of my goal about teaching hate speech, I want to be sure that they all hear the traditional view about the distrust of government power, the idea that all ideas need to be expressed, the difficulty of defining hate speech in a manner that's not vague or overbroad. But I also want them to hear the other side in terms of the great harms that hate speech inflicts on people. How, given that we have other exceptions to the First Amendment, the view that we should have one for hate speech, the view of other countries being able to prohibit hate speech without significant harm. And my third goal is to challenge all of the students to confront the opposing views. That I think the value of a class like this, or of education more generally, is that students are asked to confront their own views, to think about the opposing arguments. Perhaps they'll change their mind, but if nothing else, if they keep the same view, they'll have it much more thought out. So Catherine, in answer to your specific questions, I do several things to produce discussion. Obviously, it's how I define the classroom from the very first class and trying to make it feel like a place where all views and ideas can be expressed. Also, I teach in a structure, and the more controversial the topic, the more likely I am to structure the discussion. Let me give the example of when I cover abortion. I begin by presenting to the students 5 different approaches the Supreme Court could have taken in Roe versus Wade. And I use the discussion to elicit the arguments for and against each of them. I cover hate speech in a structure where we're talking about a larger topic so they can see where this fits. And I want to make sure that the arguments on each side come out and students on both sides get to speak. I find in teaching about hate speech, specific examples are very useful. So examples that I'll often focus on that are probably familiar to this group, an incident at the University of Oklahoma several years ago, where fraternity members were on a bus and 2 of them let led a very deeply racist chant using an unacceptable epithet. They were expelled from school. Or an example of the University of Oregon Law School several years ago, where a law professor held a Halloween party in her home and came to it in blackface and was suspended from teaching. Or the Charlottesville that rally. And I find that I get the best discussion by focusing on specific examples. Ultimately, as I say, my goal is teach them the doctrine, be sure they see the arguments on both sides, and be sure they're always questioning everything, because I want them to question everything through the semester.
Thanks, Erwin. There's a question in the chat, which actually heads us in the direction we were going to go in anyway. And it's, how do folks respond to a student who objects to working on a case to which he or she has been assigned because of their disagreement with the speech at issue? Of course, clinics are different because they have a clinical component, which involves representing clients. And when you represent clients, you have an ethical duty to zealously represent them, which can be a problem when First Amendment values clash with other values. So I want to talk a little bit about doing First Amendment clinical work, dealing with the client representation component, particularly where values clash. And so Meenu, I was hoping you could share with us a little bit about your experience when you were in the Yale clinic, looking into a Massachusetts sealing statute related to domestic violence incidents.
Yeah, so this was a clinical experience I had in Mafia some 4 years ago now when I was a 3L. It was really my first exposure in the clinical litigation setting to exactly what we've been talking about today, this clash between First Amendment values and other values. And looking back, I think it was a really tremendously valuable experience that taught me not only about these tensions, but also the role that clinical pedagogy specifically can play in wrestling with that. So Dave Schultz, who's out there in the virtual ether, knows I'm going to talk about this. So, no surprises there. But in Mafia, we had different clinical teams. You could be assigned, and I think this is the case for most clinics, you can be assigned to an ongoing case team, or you could be assigned to a scoping team that identified and pursued more novel litigation. So my 3L year, I was on a scoping team focused on the question of whether the public has a constitutional right to access arrest logs. And is there a way, if there was a way to litigate that through the First Amendment right of access or the common law right of access? And at the time, secret arrests, and that's still an issue, but secret arrests by ICE were a prominent issue. We also had in mind the more historical context of post 9/11 detentions and the like. So we had identified this bigger problem that we cared about, and we were looking to see what litigation vehicle we could use to get at that issue. And so what had been suggested was a potential constitutional challenge to two Massachusetts statutory provisions that at the time had been fairly recently amended, I think in 2014 or 2015. And what both of those laws did was seal police arrest reports in domestic violence, sexual assault, and rape cases. And they protected the identity of both the alleged abusers and the victims until a case, landed in court. And that timing is important for reasons I'll discuss in a minute. And then one of these laws pertains specifically to the university context. The other one was more generally applicable. So in my mind at the time, and my two clinical teammates' minds, we were all women, this question set up a thorny clash between First Amendment values and the privacy values and social justice goals of the laws. And on the one hand, victims advocates supported the laws because the prospect of news media coverage and publicity could dissuade victims from reporting DV, and other sexual assault crimes. On the other hand, free speech advocates were arguing that the measures, and I think there's a lot of merit to this, measures could shield abusers and potentially discriminatory police practices. For example, if the police were disproportionately charging abusers of certain racial or socioeconomic demographics. And so, looking back at this now, I think initially I had a very visceral response to this being the suggested vehicle for secret arrest access litigation more broadly. Just biographically in college, I had actually volunteered at a legal aid working with domestic violence victims. And part of my job was to conduct intake interviews. And I remember, often hearing the fear in the voices of the largely, but not universally, women who had called in to seek help with getting restraining orders. And how often, and I, want to be careful, of course, not to traffic in any generalities here, but there was so much hesitation as is in reporting abusers. And these people had summoned up so much courage and, it took so much to get to that point. I just remember thinking in clinic that, this feels intuitively wrong. I really have this hunch that getting rid of these statutes could have a real effect on this other public policy goal that we want to encourage, i.e. reporting abusers. So I think what happened next is that my teammates and I raised some of these concerns at one of our first clinic meetings. And I remember, from an educational standpoint, feeling pretty intimidated to bring this up. This had been the path set for the semester for the clinical team. The clinic director and the fellow on the case were both men. And I do remember wondering, is the onus to bring up these concerns falling on us as the students purely because we're a team of women? Maybe we are a little more sensitive to these issues, perhaps. But at the time, I'd been in the clinic a couple years. I was actually one of the student directors at the time. So I felt a bit more obligated to, speak up and take the lead. And I think the first meeting we did, I remember initially feeling a bit disappointed at the reaction. I think to me, it felt very academic and a little bit gendered. The response had been, well, let's look at Globe newspaper, Co v. Superior Court. That involved trial closures of underage victims. Let's explore what the privacy interests are. Let's explore if they're really justifiable. So, I was a little frustrated. I thought, are we not being heard? Are these countervailing interests not being taken seriously enough? Why is the onus on us to justify it? But, I very quickly realized that instinctive response wasn't enough. I still thought my teammates and I were onto something, but we needed to, bring the goods. And I really don't mean that in any kind of combative way, but I think I realized that we needed to have more tools in our kit to explain where we were coming from and, kind of back up what we were saying. So what I think ended up happening over the course of the semester was really a model of what clinical pedagogy, especially in the First Amendment space, could be. We took a multifaceted approach that looked at the facts, the law, the policy, and every week we came together, students and director and fellow teaching, came together and talked about what we had learned that week, whether we thought bringing the case was a good idea, how our thinking was evolving. So more specifically, how did we do that, and what are the broader lessons for clinics generally? First, we built cross-clinical ties. And I think this is really important in the First Amendment space, where our work traditionally, I think, has been a bit more siloed, as compared to other areas of the law, less so in recent years, but I think it is still an issue. To be cognizant of how free speech is inevitably going to run up against and clash and be in tension with these other things that we may really care about. And so instead of ignoring that or being afraid of it, incorporate that into the clinical model. And so in our case, we ended up reaching out to the TRO project at Yale, which is the Temporary Restraining Order project, which was a clinic, but it helps domestic violence victims in New Haven seek restraining orders. And what we learned from them was invaluable. They told us about something called double arrests, where if you called the police reporting domestic violence, you were often likely to get arrested yourself. And obviously that has downstream effects on employment prospects, fears of false allegations, potential for retribution if those were to become public, if the statutes were to be struck down. And then they also helped us understand, and this had been a major stumbling block for the team, why and how that initial period between reporting and arraignment, because after that it's public, really mattered to be kept shielded in terms of its effects on reporting rates, and that there really was a relationship there. And then, they also helped us probe, is this really administrable, what we might be asking a court to do, which a family court judge in their often 5 minutes, which the TRO project told us is often how long these, cases go, are they really going to be making an informed First Amendment access decision? And so I think seeking that subject matter experience outside of our First Amendment clinic was really invaluable in helping us make these decisions. And then second, we really investigated the ins and outs of the legislation. And this went far beyond doing kind of a half-baked search on Westlaw into legislative history. We ended up actually interviewing as a clinical team, all of us, the Massachusetts state representative who had sponsored the bills, and who had explained to us the interests and the historical context of the legislation. And then on the other side of the coin, we spoke to reporters who helped us intimately understand what public value this information would have, far beyond, I think, a kind of unsatisfying platitude of more access is better. And ultimately, towards the end of the semester, we decided as a team that we did not think it was responsible to bring this litigation for the countervailing privacy and public policy reasons in this particular context, the lack of empirical data at that point of the effect of the laws on reporting rates, and the general feeling that we all had that this was just not the best vehicle to generally challenge secret arrests broadly. And so I think, looking back on it now, there were definitely moments of frustration, misunderstanding, some discomfort, which I think is natural in this space, particularly on both the sides of the clinical teaching and clinical students. But as a holistic experience, I really felt engaged the whole semester. I felt empowered as a clinical student to engage in more on the ground work than I had previously done in clinic. I felt that my opinion and that of my teammates was very much valued, but we were encouraged to, bring the receipts, so to speak. So we were given the space to have these very fruitful and very provocative, I think, discussions about balancing access and First Amendment against these other, countervailing interests in a space that felt collaborative. And I think, obviously just speak for myself, but I think that both the students and the teachers learned a tremendous amount from that experience and how clinics can really, play a crucial role in these kinds of issues.
Thank you, Meenu, for talking us through that. I think it's impressive how deep you all went on that project, and then also both how much initiative you took to raise this issue, and then to credit to the clinic broadly that it could create an environment where you all could change your minds, right, about what the plan was for the semester based on what you found. Gautam, I was hoping to get you have an opportunity to weigh in here as well. I was wondering particularly how you think about maybe project scoping and taking on representations, maybe particularly like incendiary speech, or how you talk to students when you're taking on clients who might be particularly controversial.
Yeah, so I think about this a fair amount because it's an obviously foreseeable issue, although I don't think we've had a situation as rich as the one Meenu described, which I think has a lot of lessons for all of us about teaching. So, I obviously am open to whatever clients reach out to me and to us seeking representation. And we have not turned a client away, nor would I really turn a client away based on disagreement with the speech at issue for obvious reasons. Although there are other reasons that a project may not fit within the clinic just because of pedagogical goals and timelines and things like that. So we have a project, an ongoing case in which Tennessee has a criminal defamation statute that criminalizes speech in opposition to a political candidate. And in my description, I'm sure many of us can identify the multiple First Amendment problems with that law. And so we represent an organization that printed up advertisements claiming that a politician was literally Hitler because of his sort of eugenics rhetoric. And so the advertisement technically violates the law, even though it's a particularly incendiary and provocative advertisement. If you Google it, I'm sure you can find coverage of the case. It's called T-Cell, T-S-E-L versus Slattery, and there's some fun graphics there. But it's like invoking Hitler is a pretty intense thing to do, as we all are aware. And so I thought about this when taking on the case, although not for very long, because I think it was a really good case. The way that I think about these issues is at the beginning of the semester, ask students if there are any things they should know about or any cases that they would have complicated feelings about taking on. I do this for two reasons. One is that I want students to know that I am thinking about this dynamic, although it may or may not affect about how they get assigned to cases. And two, I think it gives students a venue to think for themselves, okay, what does this mean, right? What does this mean for me as a lawyer? What does this mean for me as a First Amendment attorney, in which I'm not my client, but I might have some feelings about my client? And that gives us the opportunity to have that conversation on the front end, and also gives students the space to feel that they're heard and understood based on that. And as a result, I very rarely had students say, I don't want to take on a case involving speech that targets racial minority communities, for example. Because I think students understand that in this clinic, they're going to be doing a lot of different kind of work. And as lawyers, you do a lot of different kind of work. And thus, we have to think about how to approach that work as humans, but also understand that we are there to serve our clients. And so I ask students for their thoughts about the cases and their feelings about it, and employee reflection supervision sessions, and in mid-semester and final evaluations, and in reflection essays, in order to sort of guide that conversation and discussion. But I also think that it's important for students to understand that being an attorney means that you're often going to do things that you may have mixed feelings about, and that's something to not to have a conversation about and to have some sort of acculturation to that kind of mindset. And I find that our clinic is hopefully a great space for students to do that.
Thank you. Yeah, I mean, I do think at some point you hit the ethical barrier, right, of can the student really zealously advocate for this client? And if the answer is no, probably that student can't be put on a particular matter. But yeah, I mean, those conversations are complex. And, you know, I've represented everyone from the Second Amendment Foundation to animal rights activists with really extreme positions. And sometimes you have to separate out the principle from the client's broader mission. Meenu, I want to turn back to you for a second. Could you tell us a little bit about the initiative for Representative First Amendment, just in case some folks here are unfamiliar?
Yeah, sure. And Gautam can also speak to this because I think he's had more history with it than me. But yeah, I am on the advisory board of the initiative of a Representative First Amendment founded by Kendra Albert at Harvard, in affiliation with Berkman Klein. And so what the initiative does broadly, I think, is provide financial support and fellowships and career mentorship and networking for students who are traditionally underrepresented in First Amendment law. And so what it does is it gives them funding and places them at clinics actually for part of the summer. And then also establishes this network of young First Amendment lawyers or who may or might not actually end up in actually working in the First Amendment space. But kind of more meta, I think the crucial thing that I think it does is it builds this ecosystem of the law in which First Amendment values and free expression are existing symbiotically with other areas of the law, that they're in recognizing that there are free expression dimensions to crim pro, to immigration, to labor, to repro justice, any number of things. And then I think the second really important thing that it does, and this is what Gautam was alluding to, is that it recognizes that our media law and First Amendment bar is just not as diverse as it should be, getting better, but nowhere near where it should be. And to build those connections in the First Amendment space, intellectually and with other people, you often, not always, but you often having that lived experience to recognize what might not be seen as other people as a free expression or even a First Amendment issue. So I think that's one piece of it. But I also think beyond that kind of utilitarian interpretation, the initiative also recognizes that by building this network of young lawyers who are trained in free expression values and challenges, even if they don't ultimately end up there, only more broadly contributes to a better system of free expression. And then what I think lastly, what it does by placing these fellows at clinics in particular is ensure that clinics continue to be sites of innovation and thinking that's unfettered by traditional First Amendment or media law norms. If states are the laboratories of democracy, I think clinics can be often those laboratories of legal revolution, especially in the First Amendment space. So I think the initiative gets at all of that in a really collaborative and supportive networking and fellowship program for students.
Gautam, do you have anything you want to add to that, or does that cover it?
I think that's really wonderful. And what I would add too is that there's a lot of programming for students to sort of engage with these intersectional questions of different doctrines and how we think about those. And I've spoken to the students, to the fellows at some point in the whatever COVID time has eradicated my temporality understanding. But I think it's been really great for students to sort of think a little bit more I would say counterintuitively, but in a way that sort of gets past the often caricatured, free speech versus things dynamic. And I think that's really vital for students to get at. As I mentioned, I think in our classes, and I think, Catherine and Erwin and I, we all been talking about how class settings at their best can really be a great venue for these rich conversations. And that's where I think the initiative has done its best work, is sort of creating that space. Obviously, the problem is that it takes time to create that space of knowledge, intimacy, understanding, and sharing and collaboration. But I think that's where we get the most progress in terms of understanding what different views are out there.
Thank you. We have about 10 minutes left, and I wanted to leave some time both for any questions that you all might have, but we have a lot of experienced First Amendment teachers and clinical faculty members in the audience, and so people might also want to share their own perspectives. Dave, what's the best way, if you don't mind, to facilitate that? And then also, I felt like I should give you some chance, if you wanted to talk a little bit about the experience you and Meenu shared in your clinic.
Well, thank you. I don't know if I could add much to what Meenu said. It was a very interesting experience, both for me on the other side, because I came at it with kind of these First Amendment access. Of course, we have to like deal with problems of police bias and all sorts of other things. If we, the notion of secret arrests in this country is chilling to me, and it was an educational process that was, I think, frustrating at times on both sides. But I think the process was from my perspective worked really well, and I think the resolution was a good one. Everybody came to an understanding of the different interests that were at stake, and the importance of making an informed judgment about how we should push and how we should use our resources. It was really good, and I appreciated that. I do wonder at times if there were gender issues that started this whole thing. It was an all-female team, and I think that actually turned out to be a good thing in terms of how it worked out. But I don't know. There's just all sorts of things that were at play in that whole process, and it was awkward and difficult at times. But ultimately, I think Meenu, I think, and the whole team did just a great job of like digging down and really trying to understand what was at stake, and not just kind of the surface level, what was privacy versus the public right to know, which doesn't tell you a lot. So in terms of expanding the conversation, Catherine, we can do whatever you want. People can put things in chat, but I think if people want to speak up too, they should turn on their cameras and speak up. I think these are issues that probably everybody has confronted in the course of teaching. I'm going to stop for a minute and see if anybody wants to jump in. I do think Tom Leatherberry had a question that he put into the chat. Maybe you got that, I guess, already, Catherine. So, any specific examples out there? Wow, a bashful crowd.
One thing that I found, maybe this is useful in the hate speech discussion, is that when students say that they want some more regulation, I often ask how and why, and then we start to get into the problems with that definitional question. And so I think talking through the dynamics and the challenges of, even if we could agree upon definitions, it would be incredibly hard to enforce, as well as talking about the campus hate speech controversies of the late 80s and 90s about how, who was filing the complaints and who was targeted by that, I think gives some ballast and evidence to why this is really challenging. And, I think that the deplatforming element has incident has been really useful too, to talk about the scope of private power and the unaccountability problems. And so, really, I think examples have just been a real effective pedagogical tool to sort of get students to understand that, more regulation or more control, while potentially ideal in some abstract way, is incredibly hard to implement and has a lot of very foreseeable problematic consequences that would end up perhaps being counterproductive or targeting those who we seek to protect. And so that's been beneficial. And maybe for me, in terms of expressing my ambivalence or my sort of different feelings or complicated feelings, has maybe been persuasive to my students.
I want to agree with that. I taught an undergraduate seminar for several years on free speech on campus, and one of the exercises was ask the students to draft a hate speech code. And I think that was very useful for them in seeing the difficulty in defining what's hate speech in a way that's not unduly vague and overbroad. Also, as you say, the students, I think, always were interested to learn and didn't realize the extent to which the hate speech codes have been, and the hate speech laws in Europe are used against the very groups that they're meant to protect. When the University of Michigan had a hate speech code before it was struck down, every enforcement action under it was brought against Black and Latinx students. When you look at what's gone on in Europe, you see it's so much used against the very people the students most want to protect. That isn't meant to persuade them one way or the other, but it's information often they don't have coming into the class.
I'm curious, Gautam, how explicitly you talk about your own case selection guidelines with students. And I'm asking that because that itself is, all of our clinics are, you run a First Amendment clinic, it is advancing a certain set of values, right, within certain parameters. And so I'm wondering how explicitly you discuss that with your students. as you're talking about these issues?
I do, in part because we've taken on cases that are not in this realm, but I've had sort of mixed feelings about pedagogically because they offer some benefits and others are less so. Which is to say that I think it's really important to be transparent about how clinics operate and why with students, even if they're only with me for a semester. But I do tell them that, we don't, when I turn a client away, it's not because I disagree with what the client says, it's because I don't think the project will fit well within a clinic setting. So one example for that is, I don't do a lot of amicus work because I don't think it always gives students the sort of ability to drive the representation and to take the lead. And we are supposed to be a direct services or litigation focused clinic. And so there might be a really great amicus opportunity, but students are just not going to have the time to delve in the ways that I would want, nor are they really going to be able to implement the arguments in the ways that I want. Another example of that is public records work, which is that, obviously it furthers the values that we all care about, but it's not a First Amendment issue often. And so we've only done that in situations where there's been an existing client or it's part of a larger sort of First Amendment case development strategy. That's actually an example we're dealing with right now. And so I do think that it's important for me to tell the students about how and why we take cases on. And particularly when it comes to ideology or different specific perspectives, I think that's also important to sort of let students sort of peek behind the curtain a little bit and understand what's happening and why they're doing what they're doing.
Thank you. I have one more question for all three of you, which is to what extent do you explicitly try to talk about classroom norms or ground rules for discussion at the beginning of the semester? I mean, Meena, you can talk about how useful or not you think that exercise is, but I feel like there's different ways to do this. Some people say nothing. Some people sort of preach from on high about what the classroom rules are. Some people even engage in communal conversations about what do we as a clinic community want our ground rules to be. And I was wondering to what extent you all have experiences with that.
I do so briefly in the first class of the semester. I explain my hope that all ideas and views will be expressed and that we'll always treat each other with respect. And I also try to explain why it's so important that all ideas and views and that both sides come out, that even if they're not going to change their mind, they need to know what are the arguments on the other side they're confronted as a lawyer, and their own thinking will help by hearing other side. As I've seen more of what I described earlier of students silencing each other through social pressure, I've done much more on the first day to explain why I want to be sure that all sides come out on almost all of the issues. But beyond that, I don't discuss much in terms of the classroom norms, but nor have I ever found that to be a problem. I find that the students are respectful of one another. And I do find that students are willing often to take very controversial positions.
I echo that. I don't dwell on it a ton in my intensive session before classes start, although I do say that, First Amendment cases tend to take on speech or issues that are particularly inflammatory, upsetting, controversial, what have you. And so it's just the name of the game when it comes to this kind of work. And a lot of it has to do as well beyond the First Amendment clinic, but any clinic conversation I would have, or I would tell students that we're talking about complicated issues. We're talking about cross-cultural lawyering. We're talking about their personal growth and who they want to be as attorneys. And so setting aside the First Amendment discussions, we're talking about who are my students as people and who are we to people as each other, as collaborators, as attorneys, as representatives of a client. It's going to get personal, it's going to get weird, and I tell students, it's going to get emotional. And I tell students that as every conversation with me gets personal, weird, and emotional, no matter if it's professional or not. And so I tends that up front, and that First Amendment dynamic is part of the conversation, but it's not one I dwell on, I think, for the reasons that the proof is in the pudding. And as the class hopefully gains trust with each other, and the benefit of clinic is that, you have maybe 8 students. And so that intimacy hopefully develops relatively quickly, that I've had very few issues with having to police the kind of speech of my own students happily as a First Amendment clinician, I would say.
Yeah, I think the only thing I would add, the closest I think I had to that in law school was outside the clinical setting. It was in a reproductive rights seminar that I took my 2L or 3L year. And I think in that class, it was very necessary to have some kind of conversation at the beginning, because I think that class was probably the most what's the word, emotional and uncomfortable, not in a bad way, but just, because it raised very personal issues around abortion and adoption and, all kinds of reproductive rights issues. And so I think at the beginning of the class, the professors, it was a seminar, so it was smaller, but we had a conversation about exactly what Dean Chemerinsky and Gautam have been saying about, being respectful to each other. And, if there was a point where we had a view, but we didn't want to express it, we could, send it into the professor and she would then read it anonymously to the class. And so that she allowed for that. And I don't know if that, I think there's a debate to be had about, anonymity in speech and the benefit of that in the classroom setting. But I do think in that class, it actually was really valuable because these were very, very personal cases we were reading and, triggered a lot of personal issues for, people who had various backgrounds with the issues. So yeah, that's the only thing I would add to that.
Well, thank you all. I appreciate you coming today and sharing your experiences with us. I know I've learned a lot.
Yes, let me also thank you. I think one of the hardest things, and I'm just thinking back to the experience Meena talked about too, is like where you had the burden. Like, is there a presumption that free speech is good and the burden is to show when you can overcome it? Or should you have to put the burden on those defending free speech to justify why speech is appropriate? And that seems to be just anathema to me, that even the notion of that, but I think it's my bias. And I think some of the students coming up today don't have that same perspective. It's not an assumption that first speech is good. And it can lead to some interesting conversations, but this has been really helpful. Thank you all very, very much for sharing your experience and your time. We're going to take a quick break for people who need to do whatever they need to do, and we're going to resume at noon with some really interesting discussions of things that clinics have done that have been successful that might be replicated by other clinics. So we hope you'll stick with us, and we'll pick that up at noon.
Excuse me, I have what I hope to be a quick question. Piggybacking off Professor Crump's laying down ground rules, and I turn my camera on if it worked, but unfortunately I'm using something that doesn't work. You're kind of conflating the idea of laying ground rules on discussions of the First Amendment. What do you do when students push back against that and they say, well, when people want to lay ground rules for having respectful discourse, they connect that to respectability politics, and they say it's oftentimes people in power who want to keep the status quo who use the argument that our discussions have to be respectful, we can't resort to violence, and then you have very radical responses where students might say that's used to restrain our perspective because the people in power, they have the ability to speak respectfully just keeps the status quo, if you understand what I'm saying. So how do you respond to that type of argument?
I don't find that an issue in the classroom, but I find it an issue as dean, because we've had a number of instances where students have wanted to disrupt speakers, where we had a justice from the Israeli Supreme Court speaking, and the Students for Justice in Palestine were talking about wanting to deplatform. We had a speaker for the Human Rights Program talking about the plight of the Uyghurs, and some Chinese students wanted to disrupt. And I find that I have to express the message that as a law school, all ideas and views can be expressed. If you don't like it, express your own. But if you disrupt speakers, we will discipline you. And you're right, that makes certain assumptions. But as a dean, I find I have to defend those assumptions. At the same time, if there's incidents of hate speech, I, as a dean, need to strongly condemn them as inappropriate in our community. That doesn't mean they get punished. That depends on context. But I need to express community. So I find what you say I have to deal with often as a dean. But in the classroom, I don't find that students are challenging the operation of the classroom.
I would second that, which is to say that fundamentally it's a classroom. I am the professor, right? I am running an intellectual space. I think more broadly, when it comes to sort of the law school or the university as a setting for discourse, that the frustrations that people have about individual speakers have to be contextualized, I think, in the larger sort of functioning and structure of what academic institutions are. And for many of us who work at public institutions are required to be, right? I mean, you have to be very mindful about public institutions, about who you, like how you have certain kinds of, how you invite certain speakers. And so the idea that, you know, there's certain kinds of, counter speech or conduct that should be allowed, and there's no limits on that, I think it's just not untenable for what universities are supposed to be doing. And I think we have to emphasize that as sort of those of us who are unlucky enough to have to be administering those conversations. I have empathy for, but I think I certainly agree that we, it's a function of the space, and you know, spaces are hierarchical at certain levels, and that's not to say that there can't be input from all constituents, but it is a function that there is some top-down structure and administration, and that's just how it is in these spaces.
Okay, well, with that, Dave, you're the MC. I won't preempt you.
I didn't know if you weren't going to comment, Catherine. Were there any other questions? I didn't mean to cut it off when I was sending anybody off for bio breaks, but why don't we reconvene in 10 minutes then? And again, thank you very, very much for the panel.